Okay, welcome everyone. Good morning, good afternoon, good evening. Welcome to our today's webinar. And my name is Joe, Joe John. I'm a senior law advisor at ISD's Economic Law and Policy Program. And today's webinar is on the why and how of investment dispute prevention and management agencies. So, and today we are very glad that we have a panel of distinguished speakers that are joining us. So today we're going to have the discussion with us, all of you in the same room, unlike the other type of meeting or webinars you went into in a webinar mode. So, and now let's move into the event. And first of all, I would like to welcome Dr. Susie Nikiyama, the Senior International Law Advisor of ISD and who leads the investment work at Economic Law and Policy Group. So, Susie, the floor is yours.
Thank you very much, Joe. So I was saying good morning or good evening, everyone. Sorry about that. My name is Susie Nikiyama, and I lead ISD's work on investment law. Today's webinar is part of the long-time initiative of IISD to develop innovative tools and capacity building services to support developing countries in managing investment-related disputes. Due to the growing controversies around investor-state dispute settlement, ISDS, increasing attention is being given to alternatives, either as complements or replacements of existing ISDS mechanisms. One such alternative comes in the form of investment dispute prevention and management agencies, DPMAs. There are specialized agencies or functions with the responsibility of coordinating stakeholders involved in potential investment disputes. The aim is to de-escalate tensions among stakeholders and to address potential disputes before they arise. Some countries have put the concept into practice, each with different designs and ways of operating. How do these DPMAs operate, and what are their effects in practice? Have they proven to be an effective alternative to address investment-related disputes? Will they introduce new risks? What are some criteria government may want to consider in designing and establishing effective DPMAs? What roles can international institutions have in this process? This webinar is based on the research findings of a forthcoming ISD paper regarding various countries' practices and attempts on designing and establishing dispute prevention and management agencies. This paper is co-authored by Jonathan Bonnitcha and Zoe Williams. We will share the paper with you once it is released. The purpose of the discussion today is for participants to share their knowledge and experiences so policymakers can make informed decisions on this topic. I would like now to turn over to my colleague Joe Zhang, a senior law advisor at ISD's Economic Law and Policy Program, who will introduce our experts panel and the structure of our webinar today. Thank you, and over to you, Joe.
Thanks, Susie. So yeah, with that warm welcoming remark, next I want to give a quick introduction of today's agenda. So as you can see from the presentation here, that today's discussion will be broken into three sections. First of all, we'll have Zoe, one of the co-authors of the paper that Susie just mentioned, give a quick background introduction of this working paper. And basically setting the theme of today's discussion. And then we'll have a panel discussion, which you can see from here. We have a list of distinguished guests from and experienced guests from different countries. So for that, I just want to clarify and make a general disclaimer here, because we all know dispute prevention is a very interesting topic and very important topic. And we just want to clarify that nothing discussed today, either by ISD colleague or the speakers, should be interpreted, or we don't intend it to be interpreted in any way to create any type of legitimate expectation. So, I mean, with that being said, we would like to continue with the discussion today. So next, I'm going to invite Zoe Williams to present the paper that she and Jonathan co-authored. And before I invite Zoe to speak, just a quick introduction for Zoe. Zoe Williams is an ISD associate with the Economic Law and Policy Program and Managing Director of Investment Treaty News. Her work focuses on several aspects of investment law and investor-state dispute settlement, including the domestic politics of investor-state arbitration, particularly in the mining sector, and the rise of third-party funding of investment arbitration. Prior to joining ISD, Zoe was a postdoctoral fellow at London School of Economics and a contributor at Investment Arbitration Reporter. Zoe is the author of several scholarly articles and book chapters. She is currently working on a book manuscript under contract with Oxford University Press on the politics of investment arbitration. So Zoe, I can put you on the screen here. There you go.
Okay, great. Thanks, Joe, for that introduction, and thanks everybody for coming. Jonathan and I are really looking forward to everybody's comments on this paper, and I think it's going to be really useful for us. So thank you again for that. Yeah, Joe, you can switch the slide. Great. So I'm going to start the presentation today with just talking briefly about the sort of motivation of this paper, the underlying aim of the research. And as Susie already said, that question that we were beginning with was really straightforward. What do we know about the form and function of what we're calling dispute prevention and management agencies? And importantly, what questions are still unanswered? And we begin the paper, and I'll begin this presentation with several observations to set the scene and to further frame our research. And so the first of those is that DPMAs have been framed as and can be tools to prevent and manage the risk of ISDS. But however, in some well-known cases, and we'll talk about some of those later on, they were actually developed independently of ISDS or independently of sort of thinking about investment treaties, or they've been developed as an alternative quite explicitly to ISDS. We also note at the beginning of the paper that DPMAs are something that are primarily recommended to and adopted by developing countries. And this is despite the rise in ISDS cases that we're seeing against high-income countries in the last decade or so. And then finally, this is a particularly timely reflection, I think, because the inclusion of a DPMA or something like that called focal point and ombudsman is currently being discussed in the joint statement on investment facilitation for development, sort of under the broad auspices of the WTO. So I think it's a good time to really engage with the hows and the whys of these agencies. Okay, so looking at our paper, what does our paper do? First off, it provides an overview of existing policy discussion on DPMAs, largely situated in different international organizations or institutions. And as you'll see, there's a sort of wide range of international institutions that have at one time or another been promoting DPMAs in various ways. Going forward, the paper provides a typology of DPMAs focused on variation in their design and their operational logic. And we provide several case studies of existing DPMAs to the extent that that information is publicly available. And that's a challenge a little bit with this research. And then finally, we raise some concerns or some sort of still outstanding questions about DPMAs. Joe, you can switch the slide. Okay, so the first section of our paper is really looking at the role that international institutions have played in the promotion of DPMAs. And our claim is not that all DPMAs have been established due to the advice of international institutions or their support. But we do note that, for example, UNCTAD, APEC, OECD have all published reports recommending DPMAs between the early 2000s and the present. Since 2019, the World Bank has been promoting its systemic investment response mechanism and has launched several pilot projects establishing this mechanism, this form of DPMA in various countries. And again, as I already said, the inclusion of something like a DPMA is currently being discussed in the investment facilitation process. And despite this promotion, we do raise some questions about the logic that is underlying this promotion of DPMAs. And we want to note that DPMAs can create win-win outcomes for states and investors. We're not saying, across the board, this is negative. But we think that some key issues have not received sufficient attention, especially in the way that they're framed in a lot of these reports and sort of presented as something to do, something positive, particularly for developing countries. And so the first of those really basic underlying assumptions is that all investment creates, positive spillovers, contributes to host state development, and thus should be subject to, strenuous retention efforts. And we argue in the paper that, in fact, we do see some investment projects create negative externalities for host states and their citizens or their populations. The second underlying assumption is that investment treaties themselves are necessary to attract investment while inevitably creating the risk of an investment claim, the risk of ISDS. And again, DPMAs are often framed as a way to sort of mitigate that risk of arbitration. But we argue that based on a whole host of academic studies, there's really insufficient evidence to say that investment treaties are necessary to attract investment. And then that risk of an ISDS claim is therefore not something that we should just treat as a given. And then finally, I think the most important from my perspective underlying assumption here is that investor-state disputes, whether or not they lead to arbitration, are in general the result of a lack of coordination or coordination failures, a lack of technical or bureaucratic capacity on the part of that host state, right? So why do we have investment arbitration cases? Because some government officials have made a mistake. Rather than this being the result of really political disputes, questions about resource distribution, and so on. And we argue that, that's not, if you look at the sort of whole history of known investment cases, you can't say that's true across the board. And in fact, we see a lot of investment claims that are the result of political contestation, let's say over, again, resource distribution, and can't be fixed by the sort of simple technical administrative fixes that are being proposed by DPMAs. And then we present our typology. And again, this was based on examples of existing DPMAs and would be very interested to hear participants' thoughts on these typologies and how accurately they sort of represent the reality. And so the first of these is aftercare agencies. And these, in our understanding, would be agencies that are focused on, specific problems or grievances raised by investors, and they intervene after a specific problem has been identified by an investor, and sort of in that space before a legal claim is launched. The next kind is of DPMA that we've identified are treaty compliance agencies. So this is a little different. So treaty compliance agencies, these are focused on ensuring compliance with investment treaties, across a host state's government, and really focus specifically on reducing the risk of ISDS. And again, we didn't necessarily have but we think Peru's example, or Peru's DPMA is something that comes close to that. Then we have litigation management agencies, and these are agencies with the responsibility of managing disputes that have already become legal claims. And these agencies may have some powers of decision in relation to how claims are settled. And then finally, we have administrative review agencies. And these are agencies focused on specific problems or grievances raised by investors, and they'll regularly review state conduct in relation to domestic law rather than just investment treaties, rather than focus just on that international level. And we think one of the closest examples to this is Myanmar's Investment Assistance Committee. So again, we have some case studies that I won't go into now that make up some of the paper that describe some of those real world examples. And then finally, we conclude the paper with, again, some outstanding questions or concerns that we have based on this research that we think deserve further investigation, further attention. But I won't go into those now because I think we'd much rather hear from our panel of experts and then from our audience. So I will leave that there. And again, this paper is a draft and we're really looking forward to all the comments that we might receive. Thanks.
Thank you very much, Nelly. Now we're going to move to the next section of this webinar, and I note in the chat that some participants noted the earlier presentation was not the slide is a bit blurry because I think it's because of the setting on my end. So sorry about that, but we will share the slides afterwards, after the webinar, as well as the recording. So please, and apologies in advance for that. So now for the second part of the discussion, we're going to have the panel discussion moderated by Jonathan Bonnitcha. And he is an associate with ISD's Economic Law and Policy Program. He is also a lecturer at the law faculty of University of New South Wales. Jonathan works on international economic governance with a particular focus on investment treaties. He has several years of practical experience as lawyer in investment treaty arbitration, including as a member of the legal team that successfully defended Australia's tobacco plain packaging laws against a multi-billion-dollar claim. I think we all know what it is. He has advised the governments of both developed and developing countries on investment treaty policy. And Jonathan contributed to ISD's provision of advisory services to developing countries on questions of investment governance. He is also involved in several of ISD's ongoing research projects. He is the author of numerous scholarly articles and books on investment treaties, including as the co-author of The Political Economy of Investment Treaty Regime, published by Oxford University Press in 2017. Then, of course, we have as you can see from the list here, very distinguished, yes, from Brazil, from Peru, from Vietnam. So I'm going to introduce them one by one, just quickly. And first, I would like to introduce Ricardo. Mr. Ricardo de Oliveira has been a federal public servant for Brazil since 2001. He served in the former Ministry of Development, Industry and Foreign Trade for 12 years, when he specialized in the negotiations on investments and trade and services. In 2012, he contributed to the creation of the Cooperation and Facilitation Investment Agreement. CFI, I think, is very well known by many of the participants here as well. Since 2013, he has been performing his duty at the Executive Secretariat of Foreign Trade and Investment Board in the Ministry of Economy, and was responsible for implementing what many of us are very well known now as well, the Direct Investment Ombudsman and the National Investment Committee at the Foreign Trade and Investment Board, as well as participating in the negotiation of CFIAs and in the structured discussion on investment facilitation for development at WTO. Then I would like to introduce Ms. Vanessa Rivas Plata. She is the president of the Special Commission representing the Republic of Peru in international investment disputes, leads to the sorry, I can't pronounce the acronym, but the full name is Peru's Coordination and Response System for International Investment Disputes. Please forgive me when I said that. Before, she also has served as Investment Affairs Coordinator at Vice Ministry of Foreign Trade, having participated as a lead investment negotiator of multiple international investment agreements. She has acted as Peru's investment lead negotiator for comprehensive progressive agreement with for TPP, we call now the CPTPP, the Peru-Australia Free Trade Agreement, Pacific Alliance, the trade bloc with Chile, Colombia, Mexico, and Peru, the Turkey-Peru FTA, India-Peru trade agreement, China-Peru FTA. Ms. Rivas-Pada has also represented Peru as investment experts in international forums, such as the WTO, World Bank, APEC, UNCTAD, and OECD. Ms. Rivas-Plata holds an LLM in International Business and Economic Law from Georgetown University and received her Bachelor of Laws degrees from the Catholic University of Peru. And last but not least, please allow me to introduce Ms. Uti Cha-kun, I hope I pronounced the full name correctly, is the Deputy Director General, Department of Legislation, Ministry of Planning and Investment of Vietnam. She has been participating in negotiations and implementations of BITs and IAs in free trade agreements, as well as formulating strategies and policies in this regard for Vietnam. He acted as government lawyer in ISDS, in which Vietnam is the respondent, and provided legal opinion on the interest of government of Vietnam in investment projects, such as investment in energy sector or large-scale projects which require government's guarantees. She participated in the drafting of laws and regulations on business and investment, including the Law on Investment of Vietnam adopted in 2020 and its implementation regulations. So with that, I would like to open the floor to all the panelists, and this session is going to be moderated by Jonathan. So Jonathan, please go ahead.
Thanks so much, Joe, and I'm delighted to be here, even though it's quite late here in Sydney. So forgive me if I'm not quite as coherent as I would hope, but it's wonderful to be able to have so much experience in the webinar. And I'm going to begin, Ricardo, by asking you, and then I'll ask the same question to the other speakers, just first to try to understand why was your institution set up, and particularly thinking about, I think a lot of people on the webinar will be aware of Brazil's quite innovative ACFI investment treaty program. Was the idea for an ombuds office something that came before the treaty program, or that was developed afterwards, or were they sort of developed together?
Good morning, Jonathan. First of all, I would like to thanks to this invitation and to the opportunity to say more about the direct investment movement in Brazil. Well, as you said, Brazil elaborated the CFIA, the Cooperation and Facilitation Investment Agreement, in the end of 2012. And this model was approved by CAMEX, that is the Foreign Trade and Investment Board in Brazil, in June 2013. So this model is important to note that this model has a different approach than the traditional investment promotion and protection agreements, the IPPAs, that was based on protection, use the ISDS. So the CFIA is based on cooperation and investment facilitation where the investment ombudsman plays an important role of facilitator between foreign investors and the relevant public agencies in the party to comply with the provision of this agreement. More than DPMA, the investment ombudsman is an important investment facilitation mechanism to offer the necessary support to the foreign investors in the country. The aim is to assist the foreign investors in their demands, doubts, or grievances related to the government agencies, the Brazilian legislation, and administrative procedures. So the DPMA can centralize the demands received from the foreign investors that must be answered together with government agencies involved in each case through the focal point networks. So because of this support, it will be also possible to prevent disputes, to solve some problems, and to improve the investment climate in the country. The DIO does not interfere with the powers of the other government bodies, and all the demands received and possible solutions must respect the correct compliance with the domestic and the international laws and agreements. By doing so, it will be expected not only to attract foreign investment, but also to retain the investment in the country. Thank you.
Thanks, Ricardo, for that really helpful introduction and overview. And I guess I'd like to put the same question now to Vanessa. I mean, speaking about Peru, why was your, I'm going to have a go at this acronym, so would I say CIRECI? So why was it set up? What sort of problems did you or your government have in mind when they established that institution?
Yeah, thank you very much, Jonathan, and it's secrecy. So, well, first of all, thank you very much to the IISD for inviting me to take part of this panel. I'm very delighted to share this panel with such distinguished speakers. And firstly, I want to say that any views are my own and should not be attributed to the Republic of Peru. So going back to your question, Jonathan, Peru has concluded multiple investment agreements as a policy tool to attract foreign investment to boost economic growth. As Peru engaged in negotiations of these investment agreements containing ISDS clauses, policymakers made a very clear decision to implement policies and put in place institutional frameworks in order to diminish the incidence of investment disputes generally, and to seek to address disputes before they escalate into a formal arbitral proceeding. So I would say that Peru's strategy to prevent ISDS claims and to manage them effectively has been addressed at two different levels. One, which has been focused on improving clarity in treaty drafting in order to avoid any potential unanticipated consequences in the context of ISDS. We have provided guidance to arbitral tribunals on how to interpret certain international investment agreements provisions in our modern investment chapters. And a second level of this investment preventions strategy has been focused on the institutional framework front. Back in 2006, a range of questions were raised by policymakers. And certainly 2006 was a specific year in which Peru embarked on the negotiations of its first FTA, the FTA with the United States. This FTA negotiation entailed various reforms on legal frameworks concerning intellectual property, environment, and certainly investment. So back then, there were questions by policymakers on whether it was necessary to establish rules to prevent and manage investment disputes. These questions went from asking which steps should be followed when Peru is notified by concerns from an investor. Are there any mechanisms in place to detect early investment disputes that may arise or have arisen? And a third question that was asked by policymakers was, is there any advantage in creating a lead agency that effectively monitors the measures undertaken at a central and subnational level of government that may be in conflict with international investment commitments? So in this context, Law 28933 was enacted with the aim of optimizing the response and coordination among government agencies to international investment disputes. This law created secrecy. This is the system of coordination and response to international investment disputes. The law created or established a coordinator and a special commission. The special commission is in charge of addressing investment disputes from a very early stage, from the consultations and negotiations stage to the stage in which these investment disputes have escalated into formal arbitral proceedings. This system to respond to ISDS claims contains rules on decision-making processes, rules on financial aspects to address prevention and management of investment disputes, and certainly specific provisions regarding procurement proceedings to hire outside legal counsel. So I would say that this coordination system was set up in a very specific historic, political, economic context in Peru. Peru embarked on a very active agenda of FTA's negotiations, and certainly policymakers decided that it was necessary to implement and put in place policies to be prepared for and prevent investment disputes. Certainly, secrecy has other functions in terms of litigation. The Special Commission is in charge of addressing the Republic of Peru's strategy to defend its interests in the context of ISDS claims. So that would be a general overview of the origins of secrecy and the policy rationale behind setting up this institution framework.
Thanks so much, Vanessa. One thing I think that's already interesting is that between these two quite well-known institutions, we're already seeing some difference in the function and the context in which they emerge. So in Brazil, Ricardo, if I understood you correctly, the ombudsperson role is something that emerges out of an approach to investment treaties that is designed around investment facilitation, and with that in mind, rather than investor-state dispute settlement. Whereas in Peru, the context is a bit different. That you explained, Vanessa, that that investment treaties were part of Peru's investment strategy, and that secrecy then is part of a way to manage and handle some of the compliance issues and some of the processes and risks of claims when disputes do arise. And I think that's a really interesting point to bring Quinn in. I'm sorry if I've pronounced your name incorrectly. Please correct me. But what is your experience in Vietnam? Why was your institution set up, and what sort of problems was it intended to address?
Thank you, Jonathan. You pronounced my name correctly. Thank you. First of all, please let me express my sincere thanks to IISD for giving me this opportunity to participate in this webinar to exchange information and experience with other countries in dispute prevention. Second, similar to Bonnitcha, I also have a disclaimer that the view I mentioned in this webinar is my personal opinion and not the official position of the government of Vietnam or of the Ministry of Planning and Investment of Vietnam. With regards to the Dispute Prevention and Management Agency, actually, we do not set up a separate single agency for that purely focus on the dispute prevention and management. Actually, we have two separate agency in charge of the dispute prevention and dispute resolution. The dispute prevention is conducted by the Law on Investment 2020 stated that the dispute prevention is the responsibility of all investment related agency, and every agency who when they working with the investor, when they discover any grievance by the investor, they have to assess the risk, and if they think that the risk is high enough, they should report to the relevant agency, including the Ministry of Planning Investment. So the Ministry of Planning Investment, more specifically the Foreign Investment Agency, will review the grievance and assess the level of risk with regards to those grievances and propose necessary solution or suggestion to the relevant agency or the agency who have competence to resolve the grievance. Apart from that, the management of dispute or dispute resolution, when the case has been submitted to arbitration or there is a notice of intent, most of the dispute are mainly addressed, and the lead agency for ISDS is the Ministry of Justice. The reason why in the law on investment 2020 we specifically spell out the need for dispute prevention is that when in our experience and from years of practice, we see the increasing number of pre-dispute grievance as well as the actual dispute that was brought to arbitration, and we think that the dispute is that causes very high expenses for both the government and the investor, and we think that if the dispute can be resolved in advance, that would save a lot for the society in general. And another issue is that as agents or as an ministry who in charge of managing the business and investment environment in Vietnam, we wish to retain investment and encourage new investment. And caring for existing investor is one effective way of investment promotion, especially during this time when the volume of FDI is reducing significantly. However, our system is very simple, and I can say that it is at an infant stage compared to those of other countries such as Peru, Brazil, Korea, Greece. And as I mentioned previously, the only mechanism that has been installed is the obligation of the other agency to report to the Ministry of Planned Investment on high-risk grievances. Thank you.
Thank you for that introduction, and it's interesting again to see a different model there with what you're saying, the separation of the two agencies, or the two functions of dispute prevention on the one hand, and the process of the escalation of issues as part of the way of managing dispute prevention, and the separate role for the sort of more litigation side with the Ministry of Justice. I'm interested, Quyen, just to stay with Vietnam for a second. That we mentioned in the presentation, Zoe mentioned the systemic investment response mechanism pilots that have been done by the World Bank, and we heard that Vietnam was one of the countries where that program is being piloted. Is that something that you're familiar with, and is that part of the dispute prevention system that you already described?
Thank you. Thank you, Jonathan. I think you are correct. In 2018, the World Bank assists the Ministry of Planned Investment to implement a pilot project on systemic investment response mechanism, or we can call it SIRM, SIRM. It was designed as an early warning and tracking mechanism to identify problems that arise from government conduct. So basically, we collect information from investors and other agencies on investors' grievance, and we have a team to review the grievance to assess the level of risk of each dispute with regards to the possibility of elevating into ISDS or arbitration cases. And we, after we categorize them, we propose solutions regarding each grievance and make the suggestion to the relevant agencies. However, because in the investment management system of Vietnam, most of the decision with regards to investment in, like granting investment license or revoking investment license, and addressing the land, the tax issue, all of them are taken, the measure are taken at the provincial level. So we can either suggest to the provincial authority, or we suggest to the Prime Minister to give order suggestion to the local authority. So basically, the project is more on the advising and suggesting side rather than an actual established independent agency that have the power to direct or order, to give order to other agency, or make the the team, to the SIRM project member, they do not make the decision, they or take the action to resolve the dispute. They only act as an advisor to the government.
And that's a really interesting insight about the sort of role that the mechanism takes on as an advisor dealing with, I imagine, sort of more practical and often quite mundane types of disputes at the provincial level that you describe, and in making suggestions rather than instructing provincial level governments. I wanted to ask the same question actually to Ricardo first, and then also to Vanessa. So the question is sort of how, Ricardo, you sort of mentioned that the Ombuds Office is focused on responding to investors' demands and questions, providing information to deal with doubts, but also dealing with grievances. In terms of the ways that grievances actually get resolved within that mechanism, what are the kind of tools of the Ombuds Office that they use to resolve grievances in practice?
Yes, as I said, the ombudsman do not interfere in the competence of the agencies involved, but we have a lot of meetings with the agencies involved and suggest, if it's necessary under the law, some kind of possible solution to this case. And the demand received up to now is always related to the administrative procedures. So it is more, it's easier to try to solve these problems. Okay. And we do not receive the demands that are already under the law procedures. So it's a administrative procedure.
That's really interesting, and that sounds in some ways similar to what Quin's described in Vietnam. Can you give us an example of a typical administrative type dispute that might be, or grievance that might be resolved through that sort of process?
Yes, we receive a request that we call the request that is related to some doubts, general doubts about the legislation or some administrative procedure that is easier to answer. For example, we received an enterprise requested for all pertinent information about the entry process of foreign capital for investments in Brazil. So after analyzing the demand made through the DIO system, the Brazilian central bank, that is part of the focal points network, was called to send all necessary information, and the response was sent to the investor through the DIO system. Other example is a company that intended to provide equipment supply service to Petrobras and asked some question to find out what the best way would be to operate in the country, directly or through another service provider in Brazil, and asked also about the need to registrate, to make the register with Petrobras to be able to provide the service. So after the analyzed by the DIO, the demand was sent to the Ministry of Mining and Energy regarding the necessary administrative procedures, and the other question was sent to the Attorney General Office, which listed some possible institution allowed to foreign investors in Brazil, in accordance to the national legislation. And upon receive the information, we prepare the answer and forward it to the investors.
I just want to give Vanessa a chance also to answer that question. Because one thing I found so helpful about both the examples that you've given, the sort of requests for information about entry requirements for foreign capital, and also about the best way to operate for, was it a supplier that wants to engage with Petrobras, is these are issues, these are interesting issues of information sharing around foreign investment, very practical concerns of investors, but probably not the sorts of questions or demands or grievances that we would normally associate with ISDS claims and those type of disputes. And so I wanted to ask Vanessa, with a secrecy, is your institution resolving disputes in a similar way to what we're hearing from Ricardo and Quinn, or does it have quite a different function in terms of where it's sitting within the institutional structure in Peru?
Yes, thanks so much for that question, Jonathan. Yeah, definitely it has a different design and a different objective. Secrecy has been created to respond and coordinate international investment disputes. As I mentioned previously, the special commission that is in charge of this investment prevention and management has a wide range of functions. It intervenes at a very early stage when a foreign investor submits a request for consultations and negotiations, to the formal proceeding when a request for arbitration has been delivered, and certainly Peru has to agree on steps to be followed in terms of a strategy for the defense, in terms of engaging outside legal counsel, and other financial aspects concerning investment management, investment disputes management. So the Special Commission has been entrusted with a legal mandate to assess amicable solutions in the context of consultations and negotiations. The law specifically provides the possibility to recommend a transaction, conciliation, or any form of amicable settlement in the context of potential ISDS claims. If the Special Commission considers that transaction and amicable settlement is legally and technically viable, the Special Commission recommends such formulation to the Council of Ministers. So there are two levels. A first level addressed by the Special Commission. The Special Commission assess whether this amicable settlement is legally and technically feasible. And then there is a second level in which the Council of Ministers decide whether this is an acceptable solution in terms of the grievances that are submitted to the Republic of Peru. I would like to say that having a very clear mandate on steps to be followed from day one, that a request for consultations and negotiations is triggered, provides legal certainty and predictability for both sides, for the foreign investor and for the state. the law does not provide specific forms to resolve disputes. The Special Commission has this discretionary power to assess whether an amicable settlement should be recommended to the Council of Ministers in light of the claims submitted by the foreign investor. And here I would like to emphasize that as opposed to commercial arbitration, for example, in the context of investment arbitration, the measures that are at stake are certainly measures undertaken in the exercise of sovereign powers. Sometimes, or most of the times, these measures deal with the objective to protect legitimate public objectives, such as the protection of the environment, the protection of health, the protection of safety for the well-being of the citizens. So I think that the paper that IISD had put forward touches upon this specific issue on whether the objective of these DPMAs should be to resolve the disputes at any cost, or whether there should be other elements that should play an important role in the assessment on whether this resolution is a win-win for the state and for the foreign investor. And then the analysis of the measure that is at the stake is of the essence to have clarity on whether the state should agree on an amicable settlement or should proceed to the arbitral proceeding. Certainly, sovereign states have inherent functions concerning regulations for the well-being of the society as a whole. And I found the very important in terms of precedents, the case faced by Australia in the case of tobacco packaging claims. I clearly remember that when I participated in the negotiations of the CPTPP, Australia made a very clear point on going forward with this arbitral proceeding. Certainly the underlying policy behind these label tobacco packaging policies were to protect the health of the citizens of Australia. So even though there was much pressure in terms of, well, this multinational company bringing this claim against Australia, I think the issue that prevailed was considering whether this measure was a measure that should be defended by the Australian government in light of, well, the objective that was underlying this measure. So I wanted to emphasize that issue, and I found it very important after reading the paper put forward by IISD, because certainly when a DPMA takes into consideration these grievances, these claims brought by foreign investors, there are a wide range of elements that should be assessed. And certainly one of the key elements is the measure that is at stake. If it's a measure that addresses a legitimate public objective, certainly the consideration given by the governmental agencies is focused on that specific issue. And the assessment is whether this transaction should or should not be recommended to senior authorities in light of the high relevance of this measure to be prevailed over any potential amicable settlement.
I think if I can just, because this is quite close to my heart, obviously the reference to the tobacco litigation, but I think that's just such an important point to emphasize, Vanessa, the importance in these institutions, that it's not just about settling disputes or resolving a grievance independently of a consideration of the issues that are at stake and the public interest in some of these cases. I wanted to give Quinn a chance. I can see you've got your hand up, and then after that we actually have some questions from the audience. But Quinn, would you like to briefly join the discussion, and then we will hear from our audience questions?
I'm very interested in the function of the committee in Peru, and I have one question for settlement. The committee has arranged successfully, and does the committee have the power to recommend an amount of compensation to investor?
Would you like to answer that question, Vanessa? Because it is one I think other people will have. Does the committee have the power to recommend the amount of compensation to be paid to the investor?
Yes. Thanks for that question, Queen. Yes, the law provides a very clear mandate to the Special Commission. The Special Commission has the capacity to recommend any form of amicable settlement or conciliation when this request for consultations and negotiations is submitted to the government of Peru. Certainly, if we are discussing potential compensation, there are elements that should be taken into consideration. For example, resorting to experts on damages. I think that is something that at some point has been discussed in the context of the creation of this law, how to implement this legal mandate that the Commission has to recommend an amicable settlement to the Council of Ministers. It's challenging when investors submit requests concerning compensation. But yeah, I think the law provides clarity on that legal mandate, and certainly, the Special Commission has the discretionary power to assess that possibility of potential compensation as well.
So we have some questions from the audience now, and I'm not sure, Joe, did you want to?
Yep.
Do you have an order of questions, or would you like me to just read some of them out?
Yeah, sure. Actually, we have 3 questions coming in. 2 from Dafina Atnasova, and her question is, well, two questions. She has 2 questions. One is directly addressed to Ricardo on the Brazil's ombudsman. So basically, first of all, I'd like to thank Ricardo for introducing the types of issues resolved by the ombudsman. But the question is about, what do you see the function of the ombudsperson in relation to the investment promotion agency? So what's the relationship between that two? And the second question from Tafina is to all the panelists, in your experience, in your country experience of the DPMAs, in terms of the complaints or the companies filing the complaints, what are the size? Do you see a pattern of whether they're big companies with well-structured, or are these more likely small companies, SMEs, or whether that matters? Then also I received a question from Mohammed Amir Rahman from Bangladesh, I believe, and he asked, he also asked the panelists that, do you suggest to include these type of dispute prevention management agencies in the IIAs, in the investment treaties? And if so, what happened if the investors eventually they don't agree with the outcome of the DPMA? So those are the questions we received so far.
Thank you. I would like to make the answer now. About the difference between the DIO and the investment promotion agency. I think they have different competencies. The DIO try to solve the problem or the doubts that is related to a specific government body. So the DIO have more interaction with these bodies, government bodies, to answer the demand received from the investors. And the IPA always promote the investment, the Brazilian investment abroad, and receive some investors, foreign investors, and try to help them to establish the investment in Brazil by answer some specific question about what the best location, what's the best investment facilitation or incentives from the state governments or other kind of incentives in different sectors. So the task of these different agencies is different.
Yes, and probably I could respond to the question concerning whether there is any pattern in terms of the claims and specifically the claimants that submit this request for arbitration or request for consultations and negotiations to governments. And on that, I think one of the key features of the law that created secrecy was the obligation to impose to governmental agencies to notify the coordinator of the system of any potential conflicts between investors and such governmental agencies. And I think information is key to be prepared for and to prevent and manage investment disputes. So by having this clear provision on the law that created secrecy, I think we have been able to map out potential conflicts, existent or potential conflicts between investors and the Peruvian government, and certain information on which economic sectors are more prone to investment disputes, which activities are more likely to be subject to regulatory intervention by the host state, and then give rise to these potential claims. And certainly, generally, to map out these potential controversies between the state and investors. So I wouldn't say that there is specific characteristics in terms of the enterprises that bring claims against Peru or that submit consultations and negotiations. But at this point, we have been able to map out which economic sectors are more prone to these investment disputes. And certainly that allow us to monitor these economic sectors. Certainly we do not have a regulatory mandate, but by understanding which economic activities are more prone to investment disputes, we can provide suggestions, recommendations to other agencies that are competent in terms of policy making, in terms of enacting specific regulations. So again, in terms of preparation, prevention, and management of investment disputes, I would say that information is key. And if governments can provide specific laws to oblige governmental agencies to notify of such potential conflicts, I think that would be relevant in order to address potential conflicts at a very early stage.
Vanessa, can I just jump in there, because you mentioned this under the law, this obligation on agencies to notify the committee if there is any potential dispute. How many notifications would secrecy receive each year, for example, normally?
I'm not authorized to give you a specific numbers, but certainly I would say that we have been very active in terms of receiving these requests for consultations and negotiations. I would like to reiterate that CICRES is not an aftercare agency. There are other institutions in Peru that address these aftercare functions. So at some point, I would say that some requests for consultations and negotiations address issues of aftercare, regarding aftercare coordination agencies. So when we receive these requests for consultations and negotiations, we have to make an assessment on which is the legal basis for these requests for consultation and negotiations, which are the specific measures that are at stake. And then under our legal mandate, we have the ability to request legal briefs from the governmental agencies involved in the controversies, so we can have a comprehensive assessment on the merits of the claims, and then we can proceed to analyze whether there is a potential amicable settlement. So it's a process. I would say a process that involves various steps and various agencies within the government. And certainly the law has facilitated this process. I wouldn't think how the government of Peru could face all these requests for consultations and negotiations, these investment disputes, without the law being in place. It certainly has facilitated all the coordination among governmental agencies and providing a very clear mandate on how this lead agency could require information to react quickly and to address very early this investment, at a very early stage, these investment disputes. But yeah, we are being very active in this process.
Good. Quinn, I'd like to bring you in on the question Joe asked about the types of investors and the size. What sort of investors are these? What sectors?
Thank you, Jonathan. With regards to the experience of Vietnam, we have review and assess the grievance of investor. However, we see the size of the investment of investor can vary, and some very small investor have very complicated legal issue and high risk problem. I think it depends on the type of problem rather than the size. For example, if the investor has some problem with regards to insolvency and the linkage between investment and investment arbitration and insolvency procedure, that is very, very complicated. With regards to the question on putting DPMA provision in IIA, can I address that? I think
yes,
that,
please.
This is very interesting question. However, it needs further research, and whether to put it in DPMA, it depends on the type of the functions of the DPMA, because after we discussed the three experience of the three countries, we totally had three totally different type of DPMA with different function and different purpose. So I think it depends on the purpose of the DPMA, the purpose of the treaties, and whether they can match with each other. And also it also depends on whether this is a single country DPMA or jointly established agency among the contracting parties. And I think it may be a very interesting topic for ISD to make further research on.
I think that's a really wonderful contribution. Thank you, Gwen. And one that I would echo, because something that's really stood out for me from all three speakers is really just how different these institutions are in different countries in terms of their design, in terms of the types of problems they're intended to address, and also at the stage in investor-state interactions in which they're trying to intervene. And so I think I agree with your point that any sort of suggestion about codifying or putting these in treaties is quite premature when there's actually we're not just talking about one type of institution. We're actually talking about quite a varied landscape. I wonder, Joe, do you have some more questions from the chat to bring in?
Yes, we do. Actually, we do have quite a few other questions. And actually, I do have two questions immediately followed up to you and Zoe, it seems to be, because just as Gwen was talking about the research, the need for additional research in those areas, there are two other questions that are relating to the research, basically asking whether you and Zoe, during your research phase of this paper, of seeing, first of all, do you know how many investment dispute management prevention agencies operational globally? Like how many countries do have those? What's the percentage of the countries having those agencies? That's question one. Secondly, now we've also seen the latest UNTAD report for FDI saying there are 68 new arbitration cases initiated in the past year, and most of them are based on treaties signed, as we call it, first generation treaties, or in the 90s. So is the fact of renegotiation of those treaties, or just merely assessing the exposure of ISDSs, are these also considered prevention mechanisms, prevention policies, or do you really need to have a institutional agency set up for dispute prevention? So those are, I think, more on the research side of the questions. Passing on to you, Jonathan and Zoe.
I can try and answer that first question. So in addition to the case studies that we had in the paper, we came up with 5 other examples about which we couldn't find enough information to include as a case study, but they're in the annex of the paper. So that's not a lot, right? That's not a lot of examples of these in operation that we could find. We know that the World Bank, at least, I mean, they're saying that they're doing a few pilot projects in addition to what we've included in the paper, but as far as we can tell, it's quite a small number. But maybe Jono can add to that. It's, I think, something that we found a challenge in the research was, you know, you might see an offhand mention of some kind of DPMA, or there might be you know, in a report, for example, in some of these international institution reports, but then when you go and try and locate that, let's say on the government website of the country in question, it's hard to find a lot of evidence of it existing in practice. And then to go beyond that and actually find, you know, if you can find a web presence of this agency, actually see what they're doing, see if they're taking any cases, you know, what's going on. There's not a lot of information out there on these things. It's hard to see how much of on the ground practice there really is, at least at this stage.
So just to echo what Zoe said, and also to add another point, is that there's also challenges in just thinking about what the boundaries or the criteria should be if you go out looking for these agencies, because what we've heard this evening is that they're quite diverse, and then there are other types of investment agencies, investment promotion agencies. Obviously, there are sort of more standard government legal functions that might have responsibility for defending investment treaty claims. So we didn't really think of those within our concept of what a DPMA was, although they're adjacent to it. But then if you think of what we've been talking about tonight, one of the things that comes out of our paper is I think some of the international discussion about these agencies has actually run a long way ahead of our understanding of the practice of these relatively few in number and quite diverse. And so I think one of the points of the research was kind of to, I guess, restrain some of that enthusiasm, not to say that they're necessarily a bad idea. They can potentially be really useful, but to say, well, we would be helpful to also try and understand more about how they're actually operating in practice. What are the benefits? Also, are there any costs before we go out and recommend that countries adopt agencies like this? So the fact we're doing research in this area shouldn't be interpreted as a suggestion that this is something that we're would encourage necessarily countries to adopt, but more just an area where it's important to understand more. And that relates to my answer to the second question. And then I will finish up because I can see Susie there. You know, I think revisiting old style investment treaties is a really urgent priority for countries looking to manage their risk of ISDS exposure. And it's obviously a very different type of way of responding to those risks. And of course, the two are not necessarily inconsistent. A country can renegotiate, terminate existing treaties as a way of responding to some of the concerns around ISDS, and also establish a DPMA to manage certain types of investment disputes. So they're not mutually inconsistent. But one of the things that I guess concerned us and got us interested in this research is we were quite worried that some of the promotion of these agencies was encouraging them to be seen as an alternative to addressing some quite serious concerns with old style investment treaties. And so we're very wary of the suggestion that an agency like this could be used instead of solving what are really the underlying problems with the ISDS system. And with that, I can see we've got a hard stop, and I'll hand it back to Susie to conclude the event.
Hey, Jonathan, actually, I brought Susie in because we have a question. I just want to give Susie a chance to address that question as well, but also Zoe as well, and even yourself, Jonathan, because one of the questions just came up. I think it's related to one of the slides Zoe mentioned, that the dispute prevention mechanism is actually being discussed at various international fora. And Zoe also mentioned the example of the WTO investment facilitation process, and also Untitled ISDS, etc. So there's a question asking if this has been discussed at all at the ongoing UNCITRAL working group 3 reform, ISDS reform. I brought Susie in because Susie is closely following that one. And I'm sure, I know, Zoe, you're also closely following that one. So I don't know if you would like to come in and address. And just because we are, all the speakers are speaking English, I understand most of the participants are listening in English. Just want to make sure that to let everybody confirm that our interpreters are hard working in French as well. Susie will answer this question in French, and we'll hear the English interpretations.
Merci beaucoup, Joe, pour l'opportunité de répondre à cette question et de le faire en français. Je pense aussi que beaucoup de participants aujourd'hui, y compris parmi nos intervenants, suivent de près justement ces négociations du groupe de travail 3 à la CRISED. Mais oui, c'est une question en effet qui est aussi discutée dans le cadre de ces discussions. Comme vous le savez peut-être, ces discussions sont focalisées sur l'aspect contentieux du règlement des différends des investisseurs et les pays d'accueil, mais plusieurs États dès le départ ont soulevé le fait qu'il faudrait également tenir compte de la possibilité de réduire justement l'escalade des différends jusqu'au stade du contentieux, et donc aussi réfléchir à des réformes qui permettraient d'éviter d'abord ces litiges de survenir, et si ils surviennent néanmoins, d'éviter qu'on en arrive à passer à l'arbitrage investisseur-État. Donc, ce sont des discussions qui ont lieu en cours. Il y a pas mal de problèmes qui sont posés sur la table par rapport à cette approche qui, bien qu'elle soit bien sûr pertinente et importante pour beaucoup d'États, soulève aussi le genre de questions que je pense Vanessa et Pin ont soulevé précédemment. Certains litiges ou certaines questions sont difficiles à régler autrement que par le contentieux parce que l'État ne peut pas toujours négocier ou faire une conciliation quand la mesure en question relève d'une question d'intérêt public tellement importante qu'il n'est pas possible de renoncer et de transiger sur cette question-là. Mais je pense que les autres pourront compléter. Oui, c'est une question qui est débattue actuellement au niveau du groupe de travail 3 de la CNILSI. Dans quelle mesure cela pourrait être pris en compte complètement et des réformes complètes proposées, ça reste à discuter parce que le mandat est plus sur les aspects contentieux et l'arbitrage, mais c'est clairement une question importante et beaucoup de pays insistent pour que ces aspects soient aussi débattus et que des réformes soient proposées sur ce point. Et je pense que c'est quand même un élément très important à garder sur la table des négociations.
This is a very important element which should be kept on the negotiating table. Thank you.
Merci, Susie. Zoe, do you have anything to?
Thank you, Susie.
To supplement?
Oh, nothing to add to what Susie said. I think she covered it.
Thanks all. And I think that do bring the end of today's webinar. So, and thank you once again, all the panelists, and for all the participants. As you can see in the chat box, my colleague Anchi just sent out a Google form. We would appreciate if you could take some time to fill out our evaluation form so we can do better at our next webinar. As Susie mentioned at the beginning, this is just one of the series of webinar on investment law and policy, and we'll have our next webinar in July. The topic, I think, is on damages. So we'll be sending out the invite as well in due course. So thank you everyone for attending today's event. So just as a last favor, I don't know if it would make sense to have everyone here to just open your camera if you can. We just want to take a group picture, you know, the things we usually do at the end of a webinar. Just say hi and wave to everyone so we can take a picture of you. If you don't mind, great. So if everyone is ready, I'll count backwards to 5, from 5, 5, 4, 3, 2, 1. Okay, and let me take another one. Look, 1, 5, 4, 3, 2, 1. Cha. Okay, I think I got it. Well, thank you. Thank you very much, everyone. It was a great discussion, and thank you so much again for all the panelists and speakers. And for the participants, I hope you enjoyed today's discussion as well. As promised, after the event, we'll share the slides, and we'll also upload the recordings on the ISD on this event page hosted at isd.org. So please feel free to come back, and if you have any questions, please don't hesitate to send it to us so we can forward it to the speakers or the colleagues as well. Thank you very much, and have a good day, good evening, wherever you are.